Hello students, I am Radhika and I am a researcher with a gender rights organization. Today we are going to discuss the application of human rights in the private sphere, which means collapsing the public-private divide. Human rights are classically applied between the state and the individual, which means that they govern a vertical relationship where the state holds the obligations to respect and uphold the rights of an individual. Most constitutions across the world also adopt this model, where fundamental rights are rights that are enforceable only against the state. This means that the inherent dignity of individuals, protected by human rights merely by virtue of being human, are protected only in their interaction with the state and not with other non-state private actors. In relationships with non-state private actors, these obligations are at best protected either by statute or any other law. But even so, they are not protected as human rights, but merely as contractual obligations or tortious obligations or obligations arising out of any statute. So in this module, we explore the question of whether non-state actors are also bound by human rights. Through this module, we will explore human rights theory through the natural rights theory and attempt to deconstruct the limitation of human rights within the public sphere through the natural rights theory. We expose the limitation of this human rights in the public sphere with the help of Marxist theory and feminist theory, which further analyze the need to extend human rights in the private sphere in relationships between private actors as well. In the second segment of this module, we will explore three models under international human rights law that pierce this public-private divide and provide for the application of human rights also between private actors in the private ordering of relationships. These three models are namely state responsibility, direct horizontal application, and indirect horizontal application. But briefly, what do we mean by the public-private divide when we speak of human rights? The public-private divide can be understood in two senses. One, attaching to the actor, and the second, attaching to the context. When we speak of public sphere with respect to actors, we characterize the state as a public actor and all actions arising from this state as public acts, whereas all other entities such as corporations, communities, family are all characterized as private actors acting in the private sphere. When we speak of the context, we delineate the sphere of governance, the sphere of politics and the sphere of economics as the public sphere of operation, as opposed to the private sphere of the home, which is governed by notions of emotions as opposed to the notion of rationality. This distinction between the public and the private with respect to contexts assumes more significance when we analyze gender relations and the sexual constructions of these spheres, because traditionally men are expected to occupy the public sphere of governance and economy, whereas women traditionally occupy the private sphere of the home and the community. So when we speak of the limitation of human rights to the public sphere alone, we credit this limitation to the natural rights theory. The natural rights theory assumes that individuals are free, rational and autonomous in the state of nature, and within that state of nature as free and autonomous human beings hold the rights to life, liberty and property anterior to the state. They are free to pursue their individual goals and the accumulation of wealth in the state of nature. However, this relentless pursuit of individual goals and wealth leads to insurmountable chaos and the infringement of the rights of life, liberty and property of other individuals in the state of nature. Therefore, births the state through a social contract. The state is created with the purpose of preventing this chaos providing security to individuals, while also simultaneously being obligated not to infringe the anterior rights of life, liberty and property of individuals within the private sphere. This births the divide between the public and the private, where the private is the sphere of governance, of politics and action, and therefore the realm of obligation, whereas the private sphere is the realm of autonomy, of individuality and rationality, where individuals are free to arrange their private relationships autonomously in the way they deem best fit. Now, the public and the private sphere can exist only in opposition to each other. The public sphere as the realm of governance can be defined only if there simultaneously exists a private sphere which is free from this kind of intervention and free from this kind of regulation. Marxist theory and feminist theory pose the biggest challenges to this notion of equality and rationality that orders the private ordering of relationships within the private sphere. Marx characterizes the state as a reflection of the inequality that already exists within society, arranged according to the economic status of individuals, which is further reflected in the cultural and political ordering of these relationships. According to Marxist theory, therefore, the state and human rights as the instrument of the state can only further the class interests of groups that are already powerful in the private sphere. Human rights as concepts preserve only those rights of the powerful that retain the social unequal ordering within the economic strata of society. In this sense, human rights legitimize the systemic and other inequalities that prevail within the private sphere. Therefore, what Marxist theory does is to question the egotism of the isolated individual and simultaneously reimagines this individual not as someone who is interested solely in wealth accumulation, but also as a moral citizen with obligations towards other individuals in society. Marx questioned the characterization of the individual as a rational, self-interested entity and sought to reimagine the individual within the state with a dual facet, one of the rights-bearing individual, but simultaneously as a moral citizen who owes obligations to other entities within the society as well. The second challenge to the notion of human rights within the public sphere comes from feminism and the notion of the sexual contract. Feminism contests the notion of equality of individuals within the private sphere, on the basis of which natural rights theory sought to exclude intervention of the state from the private. Carol Pateman, for instance, analyzes at length that the notion of the individual who held rights under the state within the natural rights theory was the rational, autonomous male head of the household who exercised authority over slaves, women and children within the private sphere. It was in the protection of his freedom and in the protection of his authority within the private sphere that the state is created and excluded from certain aspects. It is through this exercise that the public sphere is created as the sphere of reason, as the sphere of rationality, and as the sphere of freedom, which orders political relationships, which orders economic relationships, whereas the private is characterized as the sphere of emotion, as the sphere of love, as the sphere of blood, and accordingly the sphere of subjection, where relationships are clearly ordered in an authoritative manner. It is this division of the public sphere of reason and the private sphere of emotion, which limited the role of women as irrational emotional beings to the private sphere alone and excluded them from participation in the public. Therefore, they were denied the right to vote for a long time. They were denied the right to participation in the market and in the economy for the longest time. And even as these same rights were extended to men in the public sphere, the violations of the dignity that women faced within the private sphere was not protected by the state. Therefore, domestic violence as a human rights concept, which affronts the life and liberty of women within the private sphere, within families to a great extent, was not recognized as a human rights violation for the longest time. Therefore, in the feminist critique, the limitation of human rights in the public sphere seeks to preserve the male patriarchal order and its authority over women and children, instead of extending the same protection to the specific kind of violations that women and children might face in the private sphere. So what does it mean for the private sphere then to extend to, for the human rights to then extend to the private sphere? So as we know that human rights classically protected only individuals under the direct authority of the state, which were mostly men who owned capital and were heads of household. Marxism and feminism force us to recognize that there are individuals that inhabit different structures of authority. These structures of authority may be ordered economically, therefore the divide between the capital owning classes and the labor, or these might be, these structures of authority might be ordered in the home, therefore the inequality and the suppression of rights of slaves, women and children. But the relevance of extending human rights obligations to non-state actors in the private sphere is greatly relevant today as well, when we see the mounting authoritative value of the actions of transnational corporations in a neoliberal atmosphere, where several multinational corporations have gained state-like powers and often exceeding the authority of states as well. So for instance, corporations like Walmart earn revenue greater than the gross domestic product of several states, several African states. There have also been instances of corporations funding armed conflict in certain areas, and therefore assuming more and more public-like functions or state-like functions and occupying the public sphere more and more, creating its own structure of authority. Similarly, increasing communalization within an era of globalization permits more powerful communities existing within a society to exclude others from accessing resources like employment, like capital, or even natural resources existing in nature. So the reimagination of human rights within the private sphere has further consequences upon what kind of human rights come to be protected as well, and the nature of obligations that are further cast. So in the traditional model, where human rights are only obligations against the state, they protect first of all primarily civil and political rights, such as the right to life, to liberty, to equality, and they are classically seen as negative injunctions, preventing the state from undertaking any action that could violate the life, liberty and dignity or equality of individuals within the public sphere. But as we know that in the private sphere there is massive inequality that exists structurally or societally, pushing human rights into the private sphere means a reimagination of human rights as positive obligations that require the state to affirmatively act to eliminate inequalities within society and to affirmatively provide for opportunities that are otherwise denied to the unequals. Furthermore, this means that the emphasis accorded to civil and political rights alone needs to shift towards an emphasis on economic, social and cultural rights as well, for that enables these marginalized to access resources and access opportunities better. We now move on to the second segment of our module, in which we investigate the three models of liability under international human rights law, by which some form of horizontal application of human rights between private actors or regulating the relationships between private actors can be provided for. The first is the model of state responsibility, the second is the model of direct horizontal application, and the third is the model of indirect horizontal application. Under state responsibility, the state continues to be liable for private violations of human rights. In this sense, state responsibility doesn't necessarily provide for a horizontal application of human rights and continues to view them as a vertical relationship. All this means is that in case the human rights of one individual is violated by another private individual, then the state will be held responsible for not acting to prevent the violation of the right enough. This is reflected in several international human rights law instruments. For instance, Article 2 of the ICCPR obligates states to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant. The operative word in Article 2 being respect and to ensure. Similarly, Article 1 of the ECHR obligates states to secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of the Convention. There are other conventions across several other regional conventions that also repeat this obligation upon states, for instance, in the Inter-American Convention of Human Rights as well. So, what does the principle of state responsibility entail? State responsibility casts a twin obligation upon the state. The first is a negative violation to not violate human rights of individuals, and the second is a positive obligation to protect violation of human rights by other individuals upon a certain person. But does the mere fact that a violation of the human right of one person by another person takes place enough to attach liability upon the state? It is not. All that the state is required to do is to exercise what is known as the standard of due diligence. This standard of due diligence was explained at length in the Velázquez-Rodriguez case, which was a case before the Inter-American Court of Human Rights against the state of Honduras. This case involved the disappearance of a person known as Velázquez-Rodriguez, and it was highly suspected that the state and its police machinery was involved in the disappearance of this individual. The applicants in this case applied through the national courts, but the state was not responsive to writs of habeas corpus, was not presenting Velázquez-Rodriguez or disclosing any information about its whereabouts to his family or other members concerned about his disappearance. After exhausting domestic remedies, the applicants in the instant case approached the Inter-American Court of Human Rights, alleging that Honduras had violated the human right of Velázquez-Rodriguez by not disclosing his whereabouts and creating his disappearance, and therefore violating his right to life and liberty. The Inter-American Court of Human Rights analyzed this question at two levels. At the first level, it attributed the disappearance of Velázquez-Rodriguez to acts of the state and of the police machinery in any case. But at the this attribution was enough in itself to attach liability upon the state of Honduras. But the Inter-American Court of Human Rights went one step further. At the second level, it analyzed that even if the acts of the disappearance of Velázquez Rodriguez cannot be attributed to the state and its machinery, Honduras was still in violation of the human rights of Velázquez Rodriguez because it was not disclosing any information pertaining to his location, and was also not taking any action to ensure that Velázquez Rodriguez could reappear in his ordinary life. In doing so, the Inter-American Court of Human Rights stated that the governmental apparatus and structures must be arranged in such a manner that they are capable of juridically ensuring the free and full enjoyment of human rights of individuals within its jurisdiction. And this is what is meant by the standard of due diligence. The fact that no remedy was available to Velázquez Rodriguez or his relatives for the violation of his human rights, and that no governmental apparatus was available to them for their redress, was a violation of the rights of Velázquez Rodriguez anyway. So this implies that the state has a legal duty to take reasonable steps to prevent human rights violations and to use the means at its disposal to carry out a serious investigation of violations committed within its jurisdiction, to identify those responsible, impose the appropriate punishment, and ensure the victim adequate compensation. This notion of state responsibility for the protection of human rights between private individuals was also explored in the case of Fernandes versus Brazil. This was a case involving the redress of domestic violence between a husband and a wife. The legislations and the judicial machinery in Brazil then were arranged in such a manner that provided for immense delays in the prosecution and relief associated with domestic violence. And even as there were several delays existing within the system, there was a further provision in the Brazilian statute which said actions predating 20 years could no longer attract any kind of liability under domestic law. This meant that even as the applicant, the wife in the instant case, was prosecuting her remedies diligently and judicially, she had no access to any kind of redress or relief from the domestic courts in preventing domestic violence. And with increasing delays, her chance of accessing those remedies were also made remote. In this case, Fernandes versus Brazil, the court held that the arrangement of the judicial machinery in a manner that does not provide any redress to women of domestic violence attracts liability for the state of Brazil, even as this is a violation of human rights between two individuals, between a husband and a wife. It is the same principle of state responsibility that also orders the CEDAW, or the Convention on the Elimination of Discrimination Against Women, that obligates states to provide substantive equality to women within society, within politics, within economy, and overcome the obstacles to this equality that may be posed by private actors such as communities, such as the market or the family. The second model under international human rights law that is used to impose human rights obligations between private relationships is the direct horizontal application of human rights. As the name suggests here, human rights are enforceable against individual inter se. Therefore, any violation of the human right of one individual by another non-state actor immediately attracts liability upon the non-state actor because the human rights of the first individual have been violated, and not necessarily arising out of a contractual or a statutory claim. It is on the basis of the direct horizontal application of human rights that the Alien Torts Act statute of the United States has been enacted. Now, this is a novel feature, this is a novel legislation the world over, because it vests courts in the United States with universal jurisdiction to prosecute violations of human rights by among other entities, corporations in any part of the world, and it has been successfully used by several communities and individuals and civil society groups to hold corporations accountable for the violation of their human rights in several other geographical locations. These violations span from a denial of life, liberty, using state machinery for the oppression of individuals and communities, curbing their freedoms of speech and expression and dissent, and inflicting violence anyway. The last model which is used for the enforcement of human rights between private individuals is the model of indirect horizontal application. Under indirect horizontal application, it does not recognize that private actors themselves have human rights obligations towards other private actors. But what it does instead is to read human rights norms within other laws that regulate these private relationships, which means private law governing contracts, governing the family, governing torts are interpreted in a manner which is consistent with human rights norms and in a manner that does not violate, for instance, the freedom of speech of an individual while in a defamation case. This is based on the German doctrine propounded in the case of Luth called Mittelbare Drittwirkung, by which the private ordering of relationships between individuals is read in a manner that is consistent with their fundamental rights and which preserves the inherent dignity of both parties to the transaction. Section 6 of the Human Rights Act of the United Kingdom is also based on this similar provision, which says that public authorities are obligated to not act in a manner that derogates from the Human Rights Act, and it extends the same obligation also to private actors which are discharging the functions of a public nature. Now, this is a nuanced application of the indirect horizontal application of human rights, because it does not extend human rights obligations to all acts of all private actors, but only to private actors that are discharging public functions. So, to summarize what we have covered through the course of this module, we have discussed how classically under the natural rights theory, human rights were obligations that the state owed to individuals, and within the relationship of individuals inter se, the protection arose not from human rights, but from legislations, statutes, contract or tortious, which meant that the protection of the inherent dignity of individuals was left contingent upon the discretion of the state on whether to enact the legislation at all and what kind of protection to accord to them. To summarize what we have covered through the course of this module, human rights were classically imagined as norms that govern the relationship between the state and the individual, casting an obligation only upon the state to not violate the fundamental rights and human rights of individuals. This therefore protected only the civil and political rights and not any other kind of any other kinds of rights of individuals. Marxism and feminism enabled us to expose the incorrect assumptions on the basis of which this delineation of human rights to the public sphere was based. By exposing how the private sphere, which was assumed to be a sphere of equality, rationality and autonomy, was actually riddled with structural and systemic inequalities between individuals, and the exclusion of the state and human rights from the private sphere derogated from the inherent dignity of the unequals in those orderings. International human rights law seeks to address this flaw by extending human rights obligations to the private ordering of relationships as well. This is done through three modes. First, state responsibility. Second, direct horizontal application of human rights. And third, indirect horizontal application of human rights. In all of these three models, it is not necessary that private actors themselves may be attached with liability for human rights violations, as in the case of state responsibility. But in the direct horizontal application of human rights, they do attract direct liability for their actions. And in the indirect horizontal application of human rights, laws that otherwise govern the relationships are read in a manner that is consistent with human rights. Thank you.